can racial profiling be presented at a defense at a trial in a criminal case in the state of Oklahoma? I'm Tulsa Attorney James Wirth, and that is the question that we have. And we do have a case from the Oklahoma Court of Criminal Appeals dealing with this issue. It's an unpublished case, but it's Fletcher v. State of Oklahoma, F-2021-1319. And in that case, the defendant alleged that he was racially profiled, and because of that, his being pulled over, detained, was unlawful, and that any ill-gotten gains, anything they found, any evidence that they found based on that illegal seizure should be suppressed, which was denied by the court. And I talked about that in a separate video, but also that he should be able to present that as a defense in his criminal case. Essentially, this is what the court says. Fletcher argues racial profiling is illegal by statute, and the question of racial profiling is relevant in a criminal prosecution because if proven, the exclusionary rule requires dismissal or acquittal. So in this case, Fletcher, the defendant, had requested a jury instruction on the issue of racial profiling to put that issue before the jury, and the Oklahoma Court of Criminal Appeals is deciding on this appeal whether that is appropriate. And essentially, what it comes down to, if we're going to simplify this, is that it says that looking at their comparison to other court cases and other determinations by other courts, we agree racial profiling or selective enforcement of the law is not a defense to a criminal charge. So what they said is that you cannot present this to a jury. You cannot get a jury instruction on this issue. It is not a defense to your case, and it is not grounds to exclude that evidence. However, if you believe you have some issues, that would be something for a civil court to take care of. You can try to hire an attorney and file a civil suit against the government and see how far that gets you on that. Specifically addressing the statute, because Oklahoma does have a statute, Title 22, Section 34.3, which in subsection B says no officer of any municipal county or state law enforcement agency shall engage in racial profiling. So it is illegal by statute. But in governing what the effect is, what the repercussions are, if it's illegal but there's no consequence to it, then what does that mean? What they say is that no, this is a criminal offense. So the same prosecutor that's utilizing these officers to get a conviction against you could decide to charge the officers for racial profiling, and it would require, since it's a crime, it's required that they be the ones to do that. So it's not exactly the best mechanism for enforcing the law, since we typically have prosecutors and police officers working in conjunction to get convictions. You don't normally see prosecutors trying to undermine their witnesses in those cases. But that's what they're stating that the current lay of the law is according to the Oklahoma Court of Criminal Appeals. So if you're dealing with this issue, racial profiling, criminal prosecution in the state of Oklahoma, you're going to want to talk to an attorney privately and confidentially to make a strategy for your particular case and get legal advice for that. To get that scheduled with an attorney at my office, you can go online to makelawEasy.com.